Hey friends, in this video or this live session, I'm going to speak with you about 3 U.S. Supreme Court decisions that will make a huge impact, that are going to make a huge impact on people who have removal orders, particularly old removal orders, and those who have been seeking to cancel the removal, but the law had been stopping them. Okay, so I have a really terrific presentation that I'm going to go through with you in this live session. So if you have a few minutes, join me, learn about what's happening so that if this is touching your case or your relative's case, you're really going to want to know about this. Okay, so watch this video all the way until the end. For those of you who are new to me, welcome. I'm Latoya McBean Pompey, an immigration lawyer in New York, working with people all over the U.S. and in many different countries. And I see that folks are starting to chime in. Thank you so much. Just let me know how you guys are feeling today. Okay, so let's get into it. The Supreme Court, guys, the Supreme Court. They're coming through, right? Even with some Trump appointees on the Supreme Court, they are coming through for immigrants these days. And so let me jump right into my presentation as I see you guys are coming on. It's really nice to see you. Good morning, good morning, good morning. Okay, Supreme Court updates. These 9 individuals have so much power. And recently they've used their power to help immigrants, guys, to make it a little easier for people who are here in the United States, who are undocumented. So let's go into it. So cancellation of removal. Many of you may be familiar with this, but for those who are here who are not green card holders or residents, they have an opportunity to cancel after 10 years of being in the United States continuously. They have an opportunity to cancel their removal. They can ask a judge, and let me just get my glasses on here so that I could read this. Okay, so they have the ability to ask a judge to cancel their removal and grant them residency status. Now, there's a number of criteria that they must meet, including a good no criminal record, good moral character, those things, and in addition to having certain relatives that helps them to qualify for this cancellation of removal relief in immigration court. But there's a number of things that they must meet, and if they meet those criteria, they are able to ask the judge to grant residency status and cancel their removal. Now, the thing about this opportunity in immigration court is this: there's a rule called the stop time rule, and the clock for continuous presence in the United States actually stops when certain events happen. For example, they receive a notice to appear in immigration court. The moment they receive that notice to appear under these rules, continuous presence, physical presence in the United States stops. So it's quite possible that when that clock stops, a person can actually have less than 10 years of continuous presence, even though they have been in the United States more than 10 years. But under this rule, the clock stops when they receive that notice to appear, and thus they're not eligible anymore for cancellation of removal. And if you guys are enjoying this presentation and finding it helpful so far, just give me some hearts and likes. Okay, now let's talk about Erica. Erica, guys, this is a true story, and this is actually one of the recent decisions that just came down just a couple of days ago. Erica's story is this. Erica entered the United States on August 29th, 2007. She was not inspected. There was no admission, right? She entered without inspection. And on August 31st, 2007, she received a notice to appear in immigration court. But that notice did not have a date on it. It did not have a hearing date on it. It didn't have the time of her hearing. It didn't have those details to provide Erica with the notice that she actually needed to appear in immigration court. However, on September 10th, right, some days later, actually, the court mailed her a hearing notice with a date on it and a time. Okay, September 18th, 2007 at 9:30 a.m. she was to show up in immigration court. Then that hearing actually that was rescheduled, and she received a second notice with another date and time. And then finally she received a third notice to show up in court on January 28th, 2008 at 9 a.m. But guess what? Erica missed that hearing. She didn't show up. She didn't get notice of it, right? For whatever reason, she did not get notice of that hearing. So the judge ordered her removed in her absence, in absentia. So then many years later, in 2017, she filed a motion to reopen her case so that she could pursue cancellation of removal, because from Erica's standpoint, she had been in the United States for, those 10 years. She has 10 years continuous present, and she should be eligible at this point for cancellation of removal. Now, what ended up happening was the judge denied that motion to reopen her case, and then she appealed. She appealed to the BIA, the Board of Immigration Appeals. The BIA dismissed the case. And guys, let me just say this. Erica's story is actually quite remarkable because they never gave up. And you're going to see shortly, they never gave up. So the BIA dismissed her case, and then she took her case outside of the immigration administrative jurisdiction, and she took it all the way to the Fifth Circuit Court of Appeals, and they denied her case as well. So just to remind you, her main argument is that she never received proper notice of her hearing, because that first notice that she received did not have that date and time of her hearing. But the Fifth Circuit said she received proper notice. But what was going on, guys, also, in addition to Erica's story, what was also happening were other big cases were setting the stage for change, which happened just recently. So stick with me with the story. Now, the first big change happened in 2018 when the Supreme Court ruled, and you guys may have heard about this, the Supreme Court ruled that if the notice to appear doesn't have a time or place of the removal hearing on that notice itself, it's not really a good notice to appear. It's not a good NTA, and it doesn't trigger the stop time rule. Then, so in light of this, Erica filed a second motion to reopen her case. And she argued, hey, I have a deficient NTA. My NTA was no good. And so then she was faced with a number of denials after that. In June 2019, the BIA denied the second motion to reopen her case. She then appealed again to the Fifth Circuit Court of Appeals, and they denied it. They said she had notice from the multiple hearing notices that she received that were mailed to her, I should say. That is enough. The multiple combined, those communications is enough to provide her with proper notice. But the Ninth Circuit Court of Appeals disagreed with that, and other courts, and they said that the one NTA that she received, that NTA should have provided all of the right information, and that one NTA is the one that should stop the clock for her. Guys, remember the clock, right? 10 years. That clock stops when she received that notice to appear, and she was issued the notice to appear literally like a day after she entered the United States. So she didn't accrue, technically under that law, she didn't accrue the 10 years that she needed to now cancel the removal so that she could get a green card. So she appealed to the U.S. Supreme Court. Now, the story is actually pretty amazing because it doesn't end there. So she appealed to the Supreme Court. But while her case was there at the Supreme Court, there was another case that was also pending before the Supreme Court. And this is the one that you heard about last week. And with that Supreme Court ruling that came out last week, April 29th, the decision by the court, it was a very strong decision. The court said a single notice to appear with all the information about the notice, that is what is required to trigger the stop time rule. And when immigration lawyers heard that decision last week, we were all super excited because we knew that this was going to be very significant for a lot of people who have been in the United States for a really long time. So just to refresh your memory, based on what the Supreme Court said last week, the first notice that, remember, Erica received multiple notices, but the Supreme Court said she should have received that one NTA. That first one should have contained all of that information. And that NTA is the one that will stop the clock for cancellation of removal. And so now, consequently, many people who had a deficient notice to appear in immigration court may now be eligible for cancellation of removal. Now, what happened to Erica in light of this? In light of this, on May 3rd, the Supreme Court granted her petition and threw out the Fifth Circuit Court's decision in her case. Okay, so that's Erica's story, and this is truly a wonderful example of being persistent, never giving up, keeping the fight going, right? And so for you, if any of this resonates with you, you should get your case assessed. You should get your case assessed to see whether your case can be reopened so that you may pursue cancellation of removal in immigration court. Contact our office at McBeanLaw.com. We do these case evaluations very regularly, weekly almost, and see whether you have an opportunity to get your case reopened. So that's what happened. These three big decisions came together at the right time, and it's going to make a big difference in the lives of some of you who have been here for many years. You have strong ties to the United States. You have spouse or parents here, children here. Those individuals may suffer hardship if you have to be sent back home to your country, and maybe they have to go with you. There's just there is an opportunity now to look into whether cancellation of removal may very well be an option for you, or getting your case reopened in court, obviously, so that you may pursue this remedy. Now, immigration court, I will say this to you guys, immigration court is facing a significant backlog right now. You guys are hearing about that, right? Backlog is on so many levels with our immigration system. So this is not going to happen overnight. It's not as if, you just file that motion to reopen and your case is reopened very shortly thereafter, and then shortly thereafter you will be granted cancellation. No, it's going to take some time. But just like Erica started this journey, this litigation journey back in 2017, I believe, actually. And look how all these different pieces had to come together so that she could get the relief that she was seeking all these years. So that's what I want to leave you guys with. Visit us at McBeanLaw.com to schedule your consultation so that we may look at your case, do an assessment to see how we may help you with the motion to reopen and cancellation of removal. Also, if you're watching this on YouTube, don't forget to subscribe, hit the notification bell, and share this video with other people. Guys, thanks so much for being with me. I'm getting ready to start my consultations, and I hope you guys enjoyed the information that I've shared with you. Share it with other people because you never know who this will actually benefit. All right, guys, Thanks so much. It was really good spending this early morning with you, and I will see you in the next one. Bye-bye.